How to protect your artwork online. Hey everybody, my name is Marcella and I am a business lawyer, specifically an intellectual property lawyer, helping you with your online and offline legal needs. If you have artwork that you have created and you are wondering what is the best way to protect it, especially online, then you are in the right place. Tip number 1. You should protect your artwork online with either a copyright or a trademark, depending on which one applies to you. Now, more than likely, if we're talking about artwork, trademarks may not apply to you. For more information on whether a trademark may apply in your case, make sure to check out that video right there. But most artwork will be protected with a copyright. Now, if you've watched other videos in my playlist, you will know that at the moment you create your artwork, you already have a copyright in the artwork. But most people don't know that you should actually register that work with the Copyright Office in order for you to have maximum protection against copyright infringement. You see, you do not necessarily have the same power, so to speak, if somebody was to copyright infringe on your artwork if you had a registration versus if you did not have a registration.
If you do not have a registered copyright that you received at copyright.gov, then you will not be able to file a federal lawsuit for copyright infringement. You see, in order to bring a copyright infringement action in federal court, you have to have a registered copyright at copyright.gov.
Now, if this is something you do not feel comfortable doing, we can help you with that. Scroll down into the description, send me an email. It's always free to ask me a question. Number 2, include a watermark or something similar that will make it difficult for someone to want to duplicate the artwork, so that if they did duplicate the artwork, the watermark would go along with it. Now, does using a watermark guarantee that nobody's ever going to use your artwork, that no one's ever going to rip it off and use it as their own? Not necessarily. There are graphic designers out there that know how to use Adobe very well that might erase the watermark. And if they did that, that would more than likely be a case of copyright infringement if they use that copyrighted work in an illegal way. So in real life, that might look like somebody searching for a particular image on the internet, coming across your piece of artwork or your image, and then taking that image either through copy and paste or through saving it and then reposting it as if it was theirs. If somebody was to remove that watermark before using that copyrighted image or the copyrighted work, then that would definitely speak to their intention in using that work illegally.
Oh no!
But please pay attention to what I'm about to tell you. In order for there to be a finding of copyright infringement, it does not matter whether someone intentionally took that artwork or whether they accidentally took that artwork. There is copyright infringement in either situation. So if someone purposefully did it, that could equate to copyright infringement. If somebody accidentally took it, that could also equal copyright infringement. So there doesn't have to be a specific intent to commit copyright infringement in order for a court to find that there is copyright infringement in your situation.
It is, however, important for you to note that if there is a finding of willful infringement, in other words, somebody intentionally infringed on your copyright, then it does affect the number of damages that you would be able to secure in a lawsuit. Meaning that if there is willful infringement, you are going to be able to collect statutory damages up to $150,000. So again, statutory damages of up to $150,000 is available to those that were a victim of willful infringement. So if it was not willful infringement, if it was not intentional, then you might not be able to collect up to $150,000 worth of statutory damages.
Number 3. Another way to protect your artwork online is to report it to the different social media companies if that is where the art was taken. So for example, if you posted the image on Facebook and someone took it from Facebook and then posted it as their own, then you could report them on Facebook. If someone does that on Instagram, same rule applies. Report it to Instagram. If someone takes it from Facebook and posts it on Twitter, you can definitely make a report on Twitter. Somebody does that on Pinterest, report it on Pinterest. A lot of these different social media platforms are already prepared for these types of instances by having a place on their website where you can report an infringement. Most of the time, it's a form that looks just like this, and you fill out the blanks informing them of the situation. So that usually means telling them your name. Who are you as the person reporting the infringer? It includes telling us information about the copyrighted work. Where was the copyrighted work taken from? Do you have a link to where that copyrighted work was actually posted? And last but not least, they will ask you if you have a copyright registration. Now, I want to ask you something really important. Do you think it is going to be to your benefit to answer yes if they ask you if you have a registered copyright where you went through the procedure at copyright.gov? Well, of course, it is always going to be to your benefit if you have a registered copyright through copyright.gov. And so I really want to go back to point number 1, where I emphasized protecting your work at copyright.gov. I listed that as number 1 for a specific reason, because when you later want to point the finger at somebody who took something from you and it constitutes copyright infringement, you are going to be better off if you have a registered copyright than if you don't.
In the event that you have been accused of copyright infringement, make sure to watch that video right there where I address the defenses most commonly used in a copyright infringement case. Now, one copyright case that I will definitely be following involves Stable Diffusion, which is Stability's AI tool. Now, this is a lawsuit against Stable Diffusion, claiming that Stable Diffusion is using copyrighted works to help others generate their artistic images on the AI tool. So if you're somebody that has used AI to create artworks, then please make sure to follow this case, and also tell me in the comments below whether you have used Stability's AI tool or any other AI tool to generate art. Another copyright infringement claim worth watching is a case of Shein versus Temu. The irony is that Shein is also being hit with a class action lawsuit by small designers and artists, and also some other companies which you might recognize like For Love and Lemons, H&M, and Levi Strauss. All in all, Temu and Shein are being accused of copyright infringement, and these are cases definitely worth following.
So basically, there are advantages to having your artwork protected with the Copyright Office. If this video was helpful, make sure to give me a thumbs up down below and tell me in the comments below whether you have been a victim of copyright infringement. We would also love to see what kind of work you create, so please leave us your link down below, and don't forget to catch that video right there if you want to learn more about trademarks and whether or not they may apply to your situation as a creator or as an artist.
For more information on how we can help you with copyright infringement, make sure to check out DIYlegalshop.com or send us an email. It's always free to do so.